the Federal Reserve is unconstitutional then?
Oh goodness, I don't know if I can answer that question. The Federal Reserve is like,
It's never really been challenged.
it's like the secret society that nobody quite knows. You know, if you go to Washington and ask questions, they start picking up shiny things and spinning them in front of your face. It's strange, and goodness, part of the Tea Party movement is, in the Fed, or at least let's have an accounting of what they're doing. One way of restricting enumerated powers is, for example, putting in a restriction, for example, like the word "so long as." And so, for example, to promote this is talking about patents and intellectual property and sciences, to promote the process of science and useful arts, so long as it is done by securing for limited time to the author. So in other words, again, it's putting in a clause that doesn't just leave it wide open. There's a restriction there. These are often referred to as provisos. The words that you often find within the Constitution are words like but, or reserving, or providing that. As I mentioned earlier, some of the restrictions are located physically elsewhere within the Constitution on any particular enumerated power, because sometimes they apply to more than one power. So they place the restrictions someplace else. The Bill of Rights, which came after the ratification of the Constitution, many of the aspects of the Bill of Rights are restrictions on the power of the government. One of the aspects of this book is talking about how do you figure out the original meaning of a document, in this case the Constitution. Oftentimes when you're talking about the construction of a document, you kind of always look for the narrower meaning. But with many constitutions, when you're talking about the enumerated powers, you need to understand the intent of the makers, the intent of the people that wrote the Constitution. The meaning can be narrow or it could be broader. So you can't just use that rule of thumb of always looking for the narrow meanings. One of the examples when you get into talking about striking coin, what does to coin money mean? It's actually, when you then understand the intent of the maker, it's referring to fabrication of coin.
Which means paper money.
Paper or coin? Yeah, rocks, painted rocks. Again, we talked a little bit about fiduciary aspects of the Constitution, and it's a fiduciary agreement. Article 1 follows what was typically the process of writing a fiduciary document, very similar to a power of attorney that we call today. At that time, they referred to it as a letter of attorney. When you're talking about power of attorney or letter of attorney, you're not necessarily talking about an actual attorney of law. Instead, you're talking about an attorney of fact. So in other words, I could enter into an agreement with anyone and give them power of attorney even though they're not a legal attorney, but they then have powers, as I've specified, over my affairs. Anti-Federalists, it's always great when you read the Anti-Federalist views on different aspects of the Constitution, because the Federalists then had to come back with a counter, and it's really a way of kind of vetting out the Constitution and what it meant, and some of the potential pitfalls. They basically, when you're talking about a fiduciary agreement, you're talking about somebody that's been given certain authorities, and they're not allowed to exceed those authorities. And so in the same way, the Federalists argued that a federal agent, could not exceed the authority under the Constitution, that they were bound, and that follows fiduciary law. Another aspect, of course, and I referenced the EPA, is that when you're talking about an agent in fiduciary law, an agent cannot delegate, especially cannot delegate to a higher, providing a higher power than their own to another individual. So I kind of talked about the EPA. Here you have a non-legislative branch of our government that is creating law. And
Well,
so
all the czars are.
Yeah, and so-
Every alphabet soup does.
So Congress, in many ways, when they've established and given incredible authority to these czars, to these department heads, they've really advocated some of their authority and delegated.
Reading this, what occurs to me, this is what we're supposed to be doing, but who's upholding it? Who's enforcing it? Because what we see now in today's Congress, they don't care. They're doing what they want to do because nobody is, backing them against a wall saying you can't do that.
At the beginning of the session, after our November 2nd election, they decided to spend a day and read the Constitution, and people were screaming bloody murder over it. Basically, what it boils down to is our Tea Party should have formed 10 years ago, 20 years ago, 30 years ago. That we've been asleep at the wheel. We've been watching Ed Sullivan or whatever it was on TV at the time, and we've allowed government to keep pushing the boundaries. And it's time to start pushing back.
Well, the schools don't teach this to the kids nowadays, do they?
Nope.
And is that part of the Department of Education's
Yep.
fault because they have too many social agendas and don't have to do that?
The schools, the schools have serious problems. And right now, as far as the Constitution, the only mandate from the federal government is that on Constitution Day, that the schools would teach about the Constitution. And there's huge problems throughout our country that we need to address. And we can't address it unless we start screaming bloody murder and demand that we return to some of these original founding principles.
Well, that's sort of like medical students. They get 3 days of nutrition in their whole 10 years of education.
Okay, yes. We're going to have to go through these fairly quickly, but there's different clauses that they're talked about. For example, this is the necessary and proper clause. Necessary is talking about incidental powers. Proper likely applies to laws that must comply with the public trust. Necessary and proper is kind of interesting because this is one of those ways where Congress can go rampant by passing any law that they think that they want to pass, but that's not the case for this clause. The idea behind this clause is that you're passing things in line with your enumerated powers, that you can't exceed those enumerated powers, but you can pass laws that then allow you to accomplish those enumerated powers. It's one of those things that they couldn't have written the Constitution to address every single potential issue that was going to happen over the next couple hundred years. They had to give some leeway to Congress, but at the same time, necessary and proper. Proper, again, public trust. They're doing something that is for the betterment of the nation and not for a special interest. So, for example, when you're talking about fiduciary law, a store owner enters into a fiduciary agreement. The fiduciary agreement might be pretty limited, but some of the things that that agent is going to need to do, if they're entrusted in running this person's store, is they'll have to pay taxes, they'll have to order goods, they'll have to hire and fire. So those are kind of the incidental powers that then come from the original contract that they entered into. In the case of the government or any fiduciary agreement, the agent's discretion is limited to carrying out the defined principles and powers. one part I thought that was kind of interesting about this is that